Hi everyone, my name is Simon Misiewicz and today I'm very pleased to have with me Tim Bishop from Bishop's Law. And we've got some interesting subjects to talk about, but we're going to talk about one main subject header. Now, I appreciate we're going to be talking about divorce. Now, you might need to watch this video in secret if you're thinking about going through this process, because it's a sensitive subject, I'm sure you can appreciate. But we do need to think about marriage and divorce and all the connotations. But before we get to the details, Tim, say hello and give us a bit of a background to you and your good firm.
Thank you, Simon, and thank you for inviting me onto this. My name's Tim Bishop. I own a firm called Banalick & Bishop. We have 4 offices. We provide all the kind of legal services you'd expect, ranging from private client work, wills and trusts, to property, to commercial work. We in particular have some specialist teams. So we do a lot of work for property investors. We have a specialist property investor team who do that for clients nationwide. We also have very good litigators, and we have a particularly specialist team in lease extensions. So a team of 5 people do nothing but lease extensions, freehold purchase and right to manage. Lease extensions being the system whereby if you have a freehold, rather a residential lease, you can force the freeholder to increase it by an extra 90 years. So that's us. I'm also, however, a property investor and developer myself. So I've completed a commercial conversion. I've converted an HMO. And currently I've got 6 flats, 4 of which are serviced accommodation from my commercial conversion. And I've got an 8-bed HMO, which is doing quite nicely. And I'm looking to increase that in due course.
It's always nice, to be honest, Tim, when you can talk to a professional who also understands property and does it themselves. So there's a great deal more of empathy.
Yeah, absolutely. And I try to feed that back into the team, because it's fair to say I haven't got everything right. I've made mistakes. So we try to be very practical. And yeah, I think you're right. I think it does help if actually we understand that process.
Yeah. So let's talk about the subject of marriage and divorce. And let's talk about we need to probably bring it to the fore. It is a marriage. What should people think about when they are getting married and they've got particular assets? We talk about precautions that people can take. What's your general guidance? I appreciate there may be specifics, but let's talk about general guidance that you might give to people getting married.
I will talk in general terms. We don't tend to give that much advice before marriage. I think the only thing really we do there is prenuptial agreements. Now, you may have heard of prenuptial agreements called prenups. They're binding in many countries around the world, but they're not actually binding in the UK. So you can have them, you can create them. It's perfectly legal to create a prenuptial agreement, but the courts have said they won't necessarily be bound by them. Having said that, gradually we're moving towards a situation where the courts are paying more attention to them, but only if they're in certain formats. So the idea of somebody coming to us and paying us 50 quid just to put a rubber stamp on a bit of form saying, I've got a prenup, she or he doesn't get anything at all, that simply won't work. They've got to be properly negotiated. And by that I mean that there's got to be what's called full and frank disclosure. So both parties need to be independently represented by lawyers, and both of them need to explain in full their exact assets. So both party knows what the other one has really got. So nothing hidden. So once that's done, then you can move to a prenup. And as I said, it may or may not be binding on the court. Particularly in big money cases, the courts are starting to take more impact of them, but there's no guarantee they're not binding. But that's the only real thing you can do before you get married. After you get married, you can actually do something similar called a postnuptial agreement. They're less common, but broadly the same rules apply. You've got to have full and frank disclosure, and you've got to be both properly independently represented. So you can't turn up to the same solicitor and expect that to be done. It needs to be independent representation. That's probably the most obvious, the prenup and the postnup. There is also possibility of trusts. Trusts, again, are very complex, and I'm certainly not going to go into the details there, but there are ways you can sometimes look to protect money with trusts.
Okay. Just to clarify, prenup, postnup, I'm assuming that the time frame here is the marriage day itself. So the pre is before the marriage and postnup is post.
Absolutely. Technically, I suppose you could have a prenup done 5 minutes before you get married, and a postnup, I suppose, 5 minutes afterwards. But yeah, very simple, before and after.
Okay. I mean, it'd be an interesting conversation to be had when the man or the female or civil partner gets on their knee and says, will you be my partner, civil partner, husband, wife, provided you sign this form?
Absolutely. Yeah.
It's an interesting one.
It may well be that eventually it becomes part of British law. There have been suggestions. but it's not yet. It's not on the government's agenda, but they are gradually becoming more important.
I mean, we talk about property investors. That's what this channel is really aimed at. And we get call after call, not from people wanting to get divorced clearly, but, you know, are worried if they've, especially if they've got children, they want to protect their assets. But if they're going through a divorce, you know, just because the property is in that person's name 100%, it doesn't necessarily mean it's protected, does it?
Absolutely not. The courts are very clear here, and we need to make sure we're talking about being married or in a civil partnership. Living together is entirely different. But if you're married or in a civil partnership, broadly, the starting position from the courts, if they look at splitting up couples' assets, is that everything's put into the pot. And when I say everything, I mean everything. So if you've got a pension, that goes into the pot. If you've got family money came back 3 generations, it goes into the pot. The house goes into the pot. The cash goes into the pot. The property empire goes into the pot. In theory, that is what the family have for distribution. And then the court will look at actually what is fair to distribute. So the idea that you keep property separate doesn't really work. There is an element of doing that with trusts, but which we'll deal with in a moment. But apart from that, really, everything goes into the pot. What I should say, however, when courts look at this, and when I say when courts look at it, this is what lawyers will look at it. Even if it's not for to court, these are what the rules, if you like, by which lawyers work. It depends on the length of the marriage, for example. So if it's a very short marriage, then you probably won't see a great change in a couple's circumstances. So, for example, Simon, if you and I were modern men and we got married and then decided it didn't work out after 6 months, we got divorced after a year, quite probably we may end up actually with what we started with. However, for a couple who've been together for 20 years and had children and perhaps, you know, been in business together, that's a very different kettle of fish. And probably the starting position, it is a starting position, would be a 50-50 division. But that again depends on income and all sorts of things.
I mean, talk about that. I mean, you wouldn't want to marry me. I'm terrible at laundry. Never been very good at it. But on the main impact, you know, we have seen clients that have gone through a divorce settlement. And I think it's fair to say, just from observation, it's not been necessarily equal. It always has sided with the female or one party. Generally speaking, is that the case whereby it does side with one partner or another, or should it be split equally?
Well, the starting position with a long marriage is a straight split. But then it depends what you mean by a straight split. So, for example, if one party has a much higher income, an earning potential, then frankly, they may end up with less because the other party is going to be earning less in future. If one party ends up looking after the children, for example, if they're young children, if you split up and you've got 3 children, say, under the age of 10, then the person who's having the children full time, sometimes the children are split, will again need more money because they'll need to have a bigger house, they need to have money for maintenance, etc. So yes, the starting position is 50-50, but it really looks then at what the needs are. So it's putting everything into the pot and then seeing what the needs are. And again, people trade off. So I've got an example where a very good friend of ours got divorced, and the children by that stage, one child about 16, the rest had grown up, but he had a very good pension and a very good income. She didn't. So eventually what he did, he did a deal whereby she ended up with the house and the stables and some property they had. And broadly, he kept most of his pension and most of his income. There was no maintenance paid. So it's a trade-off. It's not a scientific formula. There's no guarantee what it is. Mainly, it's what the couple will agree. Courts only get involved if a couple can't agree. But the starting position for a long marriage without children or adult children would be a 50-50 split. But that is of everything.
Yeah. I mean, the one consideration that people should have is tax. And in particular, from my perspective, there's 2 taxes that people should think about. The first is stamp duty land tax, and the second one is capital gains tax. I'll go with the easy one first. Stamp duty land tax, I mean, from case law, if you make transfers between divorcing partners, there's no SDLT liabilities, is there?
That's my understanding.
Yeah. So that's the easier one. The next one was capital gains tax, which I appreciate, Tim, from your perspective, when you're dealing, or not you per se, but your team and other legal firms support people going from a split. One party would invariably leave the property. Now, what's really interesting, and I'll get your view on this, is HMRC say, well, the clock will start ticking the moment you leave the property, not the moment that you get the final decree, eyesight, etc., for final divorce. Because if you split the assets, all of a sudden you've now got to say, well, if I've got to buy to let, and like say, Tim, you and I are married, again, forbidding my laundry habits, but you and I have got a property, and I say, well, hold on a minute, I like this buy to let property, you've got to sell me your share, you've got a capital gains tax, and that triggers instantly, you've got, well, being together, and then post being together. So you could actually have a double whammy on capital gains tax. How much are people aware of that, do you think?
I think a lot, certainly individuals aren't. Most specialist divorce lawyers will be aware of the general circumstances. But when it comes to complicated arrangements like this, where there are multiple properties and investments, etc., then normally we'd suggest we get a specialist accountant on to help out, because as you say, otherwise you might get into all sorts of issues. So I think that the tax issues have to be looked at in the round if it's a more complicated arrangement. If it's more simple, just a straightforward house perhaps and a basic pension, you probably wouldn't need that. But once you start getting into jointly owned properties, then it becomes much more complex, particularly if there are transfers to offset pensions, for example. Yes. So, we work regularly. We regularly work with good accountants like you.
Yeah, I mean, it can even affect what was shocking was we had a couple that had separated for 2 years. One party had moved house, and then they finally got their divorce after 2-3 years of negotiating. And the unfortunate thing is they had private residency relief. Obviously, now it's just 9 months. They invoked a CGT liability of selling their home to the other party, which wouldn't have happened if they did this split before they obviously had this final divorce through and all the assets were split within a time frame. But it's amazing how disjointed HMRC and law is when it comes to divorce.
And I think tax is getting more and more and more complex, whether it's SDLT or CGT. Once upon a time, these things were relatively straightforward, but they are getting more and more complex. So I think that's why, particularly when people have assets like property, it's essential that they have a good property tax accountant who work hand in hand with lawyers in whatever they're doing, whether it's creating trusts or looking after wealth generation, wealth protection rather, or in this case, actually divorces for more complicated arrangements where there is lots of cash and money available. Yeah.
I mean, from a settlement perspective, obviously one party might have a huge tax liability if they say, well, I'm going to give away my assets. Now they've got the tax liability. They might even shortchange themselves, mightn't they? Because they've not factored in tax.
And that's why it has to be looked at in the round. That's why there's no easy answer. It's a straight split. All these things have to be assessed. One party may end up having to pay more tax for certain arrangements. So all these things are a compromise, an offset, something to make a situation where ultimately both people can live with it. Because the big problem is when you get divorced, you have one income, one set of assets, and they're divided in two. Now, whether it's equal or unequal, the one thing you can guarantee is you're going to end up with less than you started. And so it's important to make sure the taxman doesn't take a big chunk of that, which is possible.
Yeah. I mean, from your side of things, to try and summarize what people should be thinking about marriage and divorce as well, what kind of key highlights from this discussion do you have?
Well, number one, you've got to be completely open about your assets. Occasionally you find people who try to hide things. That doesn't work at all. You get in trouble if you do that, so don't do that. Make sure you're completely open with your solicitor. Make sure if you're complex arrangements, your tax accountant is aware, so the solicitor and accountant can liaise. Another factor is you usually speak to your solicitor before you move out. Often, as you say, with a couple who are together, it must be very difficult for people if they are living together in a medium or small house and they're getting on each other's nerves. It must be very difficult indeed, and we certainly see clients who really go through hell. But we always advise them to have legal advice before they move out, because not only are there tax implications, as you mentioned, but actually there are all practical implications. If you move out of the house, you're tactically in a worse position if you want to hang on to the house, for example. And there are implications there. So we would always advise someone actually speaks to a solicitor to understand their options before they make that move. So I think good advice at an early stage is essential.
Brilliant. Tim, from Tim Bishop's Law, thank you ever so much for those insights, and I look forward to having another great session on a different topic in the future. Thank you.
My pleasure. Thank you.